Good afternoon, ladies and gentlemen, and welcome to Dicentra's first regulatory webinar for 2013. Thank you for taking the time out of your busy day. Given the ever-changing climate surrounding dietary supplements and natural health products, these webinars are meant to be a non-biased source of education and information. Just a little bit about Dicentra before we begin. Dicentra provides sought-after regulatory and scientific guidance on product and marketing compliance, quality assurance, research and development, new ingredient assessments, and overall regulatory strategies for health-related products sold in North American marketplaces. Just a few housekeeping rules before we begin. First of all, due to the large volume of attendees, we will not be providing a question and answer period at the conclusion of the webinar. We will also be sending you a survey and ask you to complete it and send it back. Your feedback allows us to improve our webinars so that we are able to provide you with information we know is important to you. Lastly, this webinar will be posted onto our website at the conclusion of the day. It will also include any links that we have mentioned. I would now like to introduce Heather Van Blerken, who is Dicentra's General Counsel and Senior Regulatory Specialist. Heather is a licensed attorney with more than 10 years' experience in the dietary supplement industry. She has extensive experience in proactively helping companies achieve compliance with both FDA and FTC regulations, including labeling and advertising review, claims review and substantiation, and GMP procedures and audit. Welcome, Heather. We look forward to hearing your presentation.
Hello, everyone. I'm Heather Van Blerken. Before I begin, I'd like to cover the objectives of our webinar. First, we hope to provide you with up-to-date information pertaining to the implementation and interpretation of regulations related to dietary supplements in the United States and natural health products in Canada. We also hope to provide you with other scientific and regulatory information that has relevance to our industry. Today we will start with an overview of important developments in the United States, followed by Canada, then finish with our guest speaker, Alice Sang, from Blake's Castles and Graydon, who will present on the Canadian anti-spam legislation. In the first slide, I'd like to talk about the FDA's proposed rules to establish standards for good manufacturing practices and hazard analysis and risk-based preventive controls. The focus of this proposed rule is preventing problems that can cause foodborne illnesses. Once finalized, this rule will be applicable to many domestic and foreign firms that manufacture, process, pack, or hold human food, including dietary supplement ingredient manufacturers. Finished product manufacturers, however, that are subject to 21 CFR 111, such as dietary supplement manufacturers, are exempt, as are warehouse facilities. However, if you're a dietary supplement manufacturer that also manufactures finished food products, such as bars or meal replacements, you'll be expected to comply with this rule and have a food safety plan as well. As I mentioned, this new rule will have new provisions for the hazard analysis and risk-based preventive controls for human food. If you've seen the HACCP framework, then you'll have a familiarity with what to expect with this new regulation. HACCP was seen in the seafood and the juice. The public comment for this proposed rule closes on May 16th. They've been holding meetings in Washington, Chicago, and have another one pending. The final rule will become effective 60 days after publication, but it's likely that will happen before the end of the year. The final rule will set the dates for companies to comply. It's expected that small and very small businesses will have 2 to 3 years to comply. I'd like to turn next to the FDA's draft NDI guidance. First, let me spend a few minutes talking about what an NDI is. An NDI is a new dietary ingredient, so one that was not marketed in the United States prior to October 15, 1994, when DSHEA, the Dietary Supplement Health and Education Act, was implemented. Manufacturers, importers, and distributors generally must provide the FDA 70 days notice before bringing a product to market that contains a new dietary ingredient. The notice must demonstrate that the dietary ingredient is reasonably expected to be safe under the conditions of use on the label. Because the conditions of safety are specific to the use on the label, every manufacturer or distributor who wishes to market that ingredient must file their own notification. Marketing a product that contains a new dietary ingredient that hasn't gone through the notification process would be considered to be adulterated. The Dietary Supplement Industry Trade Associations is working with the FDA on revisions to the draft guidance that was initially issued in June of 2011. The topics that they are discussing as part of the revisions include chemical alteration, synthetical botanical constituents, duplicative submissions, and also the identity of the new dietary ingredient. The trade associations are hoping to focus on the new dietary ingredient identity since this is the area that has historically caused the most confusion for companies that have submitted the NDI notifications. The next meeting that industry has with FDA will be on April 2nd, 2013. I'd also like to update you on the happenings of the Palm Wonderful case. This case was initially filed by the FTC in 2010. And in January, on January 16th, 2013, the FTC issued its decision. And most recently, on March 8th, 2013, Palm filed a petition for review of the FTC order in Washington, D.C.'s District Court. The FTC, when it issued its decision in January, held that two randomized, well-controlled human clinical trials were required to substantiate the claims at issue. And the claims that were in issue in this case were related to heart disease, prostate cancer, and erectile dysfunction. However, the court was very careful to limit the findings to the specific disease treatment and prevention claims that were at issue in this case, and not health claims generally. The commission disagreed that the findings of liability would violate the respondent's or Palm's First Amendment rights. The commission also found that the FDA pre-approval is not required for future advertising claims. However, the final order does require at least 2 clinical trials for future disease prevention, risk reduction, and treatment claims. Structure function claims were not at issue in this case, and the FTC didn't reach any conclusions in terms of the type of substantiation that would be required. However, because the FTC is obviously looking to use that as a standard, in their cases you can expect to see them using it in future consent decrees as much and as frequently as they can. California's Proposition 65. Most recently, on February 15th, 2013, the trial court in California upheld the decision that supplements are considered foods in California. Let me spend a minute just explaining what Proposition 65 is. Under Proposition 65, consumer goods sold in California must generally provide a clear and reasonable warning if chemicals listed by the state as carcinogens or reproductive toxins are present above specified limits in the regulations. For food products, the limits that trigger a warning requirement are those that are present in excess of any naturally occurring amount, including presence as a result of absorption or accumulation of the chemical which is naturally present in the environment, so long as the chemical did not result from any unknown human activity. So the recent court decision finds that the supplements are considered food and are entitled to that naturally occurring exemption. So don't misunderstand the decision that Prop 65 still applies to dietary supplements, but now they're essentially allowed, an exemption for a small amount for the naturally occurring lead that may be found in the product when tested. As you know, we've talked about in the past the FDA warning letters. I want to spend another few minutes updating you on recent warning letters. First, I'd like to talk about some of the common violations that are found with the manufacturers. And again, these are violations of 21 CFR 111. Unfortunately, the FDA is still finding violations of the very basic good manufacturing practices. And these include things like no master manufacturing records, no batch records, no finished product specifications, no finished product release criteria, no quality control in general, and also significant plant deficiencies, physical plant deficiencies such as no traps, such as no cleaning, standard operating procedures, and they're also finding disease claims on the labels and the websites. But I also want to make sure that everyone is aware that 21 CFR 111 applies not just to manufacturers of dietary supplements, but also sales, marketing, and distributing companies. The FDA refers to those sometimes as own label distributors, and we've been seeing warning letters being given to those companies as well, because you're ultimately responsible for complying with the regulations required for manufacturers, even if you hire another person to do that job for you. Specifically, if you're a sales, marketing, distribution company, you need to make sure you have quality control personnel, written procedures, and if you do packaging and labeling, master manufacturing records for each unique formula and for each batch size. You'll also need packaging and labeling specifications, written procedures for returns or product complaints, and procedures to hold and collect reserve samples of each lot. You'll also need information from your from your suppliers for your product. You'll need to have established specifications to provide sufficient assurance that the product you receive from a supplier is consistent with the purchase order, and must make and keep records of those specifications. If another firm is manufacturing your dietary supplements for you, you need to make sure that you know what and how manufacturing activities are being performed to enable you to make decisions related to whether or not your products are conforming to the established specifications and whether or not you should approve and release those products for distribution. You're also required to have records related to the manufacturing operations, or at least be able to readily have them available to you upon an inspection by the FDA. For a few minutes, I just wanted to talk about some of the new trends in warning letters that we're seeing that you should also be alerted to. They've been talking about companies' failure to substantiate the best buy date or the expiration date. They've been noting that employees have never received any training whatsoever. They've also been pointing out that there's been evidence that product has been distributed before being released by quality control. And they've also pointed out in a warning letter that it's insufficient to claim that the vice president had authority over the quality control to release a product, or that you just can't afford the equipment or the quality personnel to oversee such operations. Most recently, as we'll talk about in a little bit, they've also been targeting and looking at the adverse event reports that the company's been receiving. We've also seen recently joint FTC and FDA warning letters have been issued, mainly related to companies with cold and flu products. And in these instances, not only does the company have to respond to the FDA, they also have to respond to the FTC. And the challenge with the FTC is not only do they want you to correct the problems, but they're usually seeking consumer redress. And consumer redress is your gross total sales. So not just your profit, but gross total sales. And I just want to make sure everyone's aware of the ramifications for failure to correct these violations. A violation means that your product is adulterated and essentially an unapproved new drug. So the warning letters have been pointing out that failure to promptly correct these violations may result in enforcement actions without any further notice. And those can include seizure of the products that are adulterated and also an injunction to stop the manufacturing and distribution of your products until they are compliant. And lastly, I want to hit on some recent topics that have been of interest in the United States. First, the GMO labeling has been gaining momentum. Initially, the proposition was defeated in California, but it's been followed by a series of other bills and proposals in a number of other states. And currently, there's no federal law on the issue, but some industry is calling for a national standard. Currently, the federal law does not require the labeling of genetically engineered foods, as the FDA has consistently argued that they do not differ from other foods in any meaningful or material way, or present any different or greater safety concerns than foods developed by traditional plant breeding methods. However, because so many states are starting to devise their own bills and rules, many in the industry are coming of the opinion that it's worthwhile to have one uniform national standard. And at this time, there's no bill yet federally that's been proposed, but there's been one representative working on a federal bill. Next, Senator Durbin is continuing to push for increased regulations of dietary supplements. On March 19th, Senator Durbin said he'd be reintroducing the Dietary Supplement Labeling Act, which he originally introduced in 2011. And in this act, he's hoping to impose what the industry feels is unnecessary regulation, because the dietary supplement industry is regulated. His labeling act would require companies to give the FDA the name of each label they produce, along with a description, a list of ingredients, and a copy of the label. And this would apply to not only, this would apply to every product being manufactured, and would put the requirement on the manufacturers, and also notify the FDA anytime you stop manufacturing a product. And Senator Durbin is also leading the energy drink controversy. He's trying to mandate stricter guidelines for energy drinks as well as the dietary supplements. In his opinion, energy drinks are marketed as dietary supplements instead of beverages, leading them to be regulated more laxly. However, a lot of the big players in the energy drink market, such as Monster and Red Bull, are starting to market their products as foods, and you'll start seeing nutrition fact panels instead of supplement fact panels on these products. The issue there becomes whether or not the ingredients that they're going to be marketed as foods are all going to be GRAS ingredients or generally recognized as safe. So there may be an issue as to whether or not there has to be a formula change. Currently, all the companies that are making the transition are claiming there's no need for a formula change. And by switching them to foods instead of dietary supplements, there'll be no need for them to submit adverse event reports, because that's not currently required for food products. Some of the states or different little cities and counties have attempted to ban or prevent the sale of energy drinks. Chicago attempted an energy drink ban, but it didn't lead to a vote and only an agreement for further discussion. However, Suffolk County did impose on March 19th a law to ban the sale of energy drinks to minors at county parks and beaches. And lastly, I want to talk just quickly about GAO's report on ADRs that was recently released on March 18th. Since December 2007, firms receiving a serious adverse event have had to report it to the FDA within 15 days. Well, the GAO was asked to examine FDA's use of AERs in overseeing the dietary supplement industry. The report examines first the number of AERs the FDA has received since 2008, their source and types of products identified, 2, actions FDA has taken to ensure that firms are complying with the AER requirements, 3, the extent to which FDA is using AERs to initiate and support its consumer protection efforts, and 4, the extent to which the FDA has implemented GAO's 2009 recommendations. What GAO found was that from 2008 to 2011, the Department of Health and Human Services, FDA's, received 6,307 reports of health problems or adverse events for dietary supplements. 71% of those came from industry as serious adverse events as required by law. And most of these were linked with supplements containing a combination of ingredients, such as vitamins and minerals, or were otherwise not classified within the FDA's product categories. However, there was some concern that the FDA may not be receiving all of the information because some of that may be going to poison control centers, which the FDA doesn't currently have access to. To help ensure that firms are complying with the AER requirements, that is, submitting the serious adverse events and maintaining the AER records, and including also, is important to note, the company's contact information on product labels. The FDA has increased its inspection of dietary supplement firms and took some actions against non-compliant firms. Specifically, the FDA increased firm inspections from 120 in 2008 to 410 from January 1st to September 30th in 2012. Over this period, FDA took the following actions: 3 warning letters, 1 injunction, and 15 import refusals, all related to the adverse event violations. And one of those actions would be for not including the contact information on the product label or submitting serious adverse events. Before we jump to the Canadian information, I want to take a brief moment to let you know that Dicentra has recently launched GMP online training for dietary supplements. This will allow you to avoid travel and expensive seminars. For one flat rate, you'd get unlimited annual access to our GMP training program online. You can use it company-wide from 1 employee to 1,000 employees. Everyone can train themselves at their own pace from the comfort of their desk. Please visit the website below for more details. I would now like to introduce William Morkel, who is Dicentra's Director of Quality and Compliance. William has over 10 years of experience working in the field of pharmaceutical and natural health products, quality assurance. His background includes professional teaching and training and auditing with respect to both good manufacturing practices and ISO standards.
Thanks, Heather. As you saw in the introduction, we have quite a few items to cover on the Canadian side, so I'm going to proceed at a fairly brisk pace, starting with what is probably the biggest development since our last update, and that is, sorry folks, some technical difficulties here, the repeal of UPLAR. UPLAR, or the Unprocessed Product License Applications Regulations, officially expired on February 4th, 2013, as they were meant to do. The regulations deliberately had this sunset clause built into them. As a result, all ENs, or exemption numbers, as of that date are no longer valid. There will, however, be an 18-month transition period that will unfold in 2 9-month phases. We get many questions about this transition period, particularly from an enforcement perspective, so I do want to go over these phases in some detail. The first phase will last from March 1st, 2013 to November 30th, 2013. During these 9 months, the inspectorate will not focus their enforcement actions on NHPs that A, have a submission number and do not pose an undue risk to health, or B, that have a license but have undergone minor modifications during the licensing process. Now, does all of this sound familiar? It should. This is the same enforcement policy that they have been following for the last 9 years. However, during this period, companies are expected to phase out non-compliant products from their manufacturing and importing operations. Notice that I have underlined those 2 specific activities. By the end of the 9 months, companies should be companies should not be manufacturing or importing products that are not licensed and that do not comply with their marketing authorizations. And this is the take-home message for this slide. You have 9 months, well, actually 8 months now since we're already at the end of March, to phase out the manufacturing and importation of non-compliant products. The second phase will last from December 1st, 2013 to August 31st, 2014. Over these 9 months, retailers and distributors are expected to phase out unlicensed products. As mentioned, at the importation and manufacturing level, NHPs will be expected to be licensed and to meet the terms of their market authorizations during this phase. Again, at the retail level, enforcement will not focus on distributed products that have submission numbers and are low risk. Following the end of the 18-month transition phase, as of September 1st, 2014, all marketed NHPs must be licensed and must comply with the terms of their marketing authorization. So complying with the terms of your marketing authorization, what does that mean? It means that you are labeling the product with the approved claims and only the approved claims. You are manufacturing the product to contain the approved ingredients and the approved amounts, etc. In other words, you must not only have a license, but you must be marketing the product in accordance with that license. The NHPD has stated that they are going to release a guideline on the impact of the repeal on advertising shortly, and this will likely be geared to the advertising pre-clearance agencies in terms of the approaches that they should be following when reviewing ads during the transition period. And for more information concerning the end of UPLAR, you may read the questions and answers document on the NHPD website under their What's New section. Okay, our next item is the NHPD Status of Applications Quarterly Report. On March 1st, the NHPD posted their report for the third quarter of their current fiscal year. Now, this document is about 20 pages of statistics, and I don't want to bore you with the details, but I do want to highlight some of the more salient statistics. From January 2004 to December 31st, 2012, i.e. since the regulations came into effect, the NHPD has received 73,669 product license applications. At the end of 2012, the NHPD has issued a total, or as of the end of 2012, the NHPD has issued a total of 41,255 product license applications, representing 59,382 products and 2,045 companies. I can add that these statistics, as I said, are to the end of December, but I can also mention that as of the end of February, they issued an additional 1,849 licenses. The percent of pre-UPLAR applications completed is now 99.8% of a total of 10,885 that were received before August 5th, 2010. There are still a few stragglers, about a dozen or so, but for all intents and purposes, the pre-UPLAR backlog has been cleared, and that is the main message that I wanted you to take home for that previous slide. What about after the implementation of UPLAR? So of the 23,138 submissions, including amendments received after August 5th, 2010, that is post-UPLAR, 46% of these met NHPD's pre-cleared information. Of this 46%, the NHPD has been meeting their internal 60-day completion target 99% of the time. So why am I bothering to mention this? Because it means that if you submit a pre-cleared application now, you can fully expect to get a license in 60 days. And that may be important for some of you when it comes to planning your product launches. Of the remaining applications, 9,470 required full assessments and received application acceptance letters, and the NHPD has completed 73% of the workload. Of the 73%, the NHPD has been meeting their internal 180-day completion target 62% of the time. Now that 62% internal success rate may not look all that great, but remember, these are mainly UPLAR figures. Now that the UPLAR backlog is cleared, I fully expect that the NHPD will meet their internal targets moving forward. Of the 73%, 85% of them received an NPN, 15% were refused, and a small percent, 69 submissions, were withdrawn by the applicant. So that gives you an idea of the ratio of NPNs to refusals, and the refusal rate for full assessment applications is about 15%. And then just some additional statistics. Of the 405 clinical trial applications received since January 2004, 98% are completed. Of the 2,027 site license applications received since January 2004, 99% are completed. And of the 2,773 site license renewals received, 98% are completed. I included these statistics just to show that there is no backlog in these areas, and we personally at dicentra are finding that the NHPD is turning around these type of applications fairly quickly. Okay, the next really big development since our last update concerns the pathway for licensing natural health products guidelines. The final pathway guidance documents were posted on the NHPD's website on December 27th, 2012. The old evidence for safety and efficacy of finished natural health products is now replaced by two new guidance documents. Pathway for licensing natural health products used as traditional medicines, and Pathway for licensing natural health products making modern health claims. The changes were substantial and they were discussed to some extent during our last webinar, so I'm not going to go into any detail. I do just want to highlight four or five of some of the more important features. Safety and efficacy will be assessed according to a risk-based approach. Now, this has always been the case. However, the new modern claims guideline establishes three risk levels: low, medium, and high, and clearly delineates the types of evidence needed to support each. The modern claims guideline also now permits implied health claims, example, source of fiber. Such standalone claims were not permitted in the past. The modern claims guideline also includes a general health claims annex that provides specific details on how to utilize weaker forms of evidence in support of health claims. In other words, it is potentially easier now to substantiate and consequently license lower risk health claims. Traditional claims can now be applied to ingredients in combination products. Example, traditional ingredient plus non-traditional ingredient, or traditional ingredients from different paradigms. And this was not allowed under the old guidance document. And a time span representing 2 generations of safe traditional use is now considered acceptable for supporting long history of use for traditional medicines. Before, it was at least 50 consecutive years. Now it's 2 generations, which one of my colleagues, Ashley Thurston, our Manager of Scientific Affairs, confirmed with the NHPD is equivalent to 30 years. So that's 50 years before versus 30 years now. Again, I'm just highlighting these particular points because they were at one time such bones of contention when licensing certain products. Now I would like to mention some NHPD monograph updates. I'm not going to go over the changes made to any monograph in particular. I'm simply listing here the ingredient monographs that have been updated since our last quarterly webinar. If you have licensed products containing these ingredients, or if you're in the process of formulating products with these ingredients, then you should take a look at these monographs to see if the changes impact your products. So the following monographs were recently modified since our last quarterly update, and the final revisions are now posted. Active hexose correlated compound in granule form, active hexose correlated compound in powder form, amla, cassia cinnamon, donquay, poria, quercetin, rutin, acai, cinnamon, maca, male genital desensitizers, benzocaine, reishi, and tribulus. New monographs for the following were posted for stakeholder feedback on January. That should be January 29th of this year. So they have not as yet been finalized, and that is the NOSODS and homeopathic medicines monographs, and these are 2 separate monographs. Proposed revisions to the following monographs were posted and are under current review, and that is the fish oil, melatonin oral, melatonin sublingual, Echinacea augustifolia, Echinacea pallida, and Echinacea purpurea. The consultation period for these last 3 Echinacea ingredients is still open, so you have until April 9th to submit your comments to the NHPD if you wish to do so. Next, I want to say a very brief word on the new Quality of Natural Health Products Guide, and my update is that there is nothing to update. However, the NHPD has said that a finalized version is set to come out this month, sometime during March, so we may see something in the next few days. Version 3 of the Quality of Natural Health Products Guide was open for consultation from August 31st, 2012 to November 30th, 2012. This guidance document has been in the works for years now, and waiting for its arrival has been a bit like waiting for Godot. Final posting was slated to come out several times, but was repeatedly postponed. However, as per the NHPD, we should expect something very soon. Okay, my next topic affects not only NHPs, but drugs in general, and that is the consultation on the new prescription drug list. Health Canada is proposing a new prescription drug list, or PDL, to replace the existing Schedule F to the Food and Drug Regulations. I need, however, to mention a few caveats. First, the list of ingredients itself is not being revised. All ingredients currently on Schedule F will automatically be included in the PDL. Second, as with Schedule F, PDL ingredients will not be permitted in natural health products, so nothing will change in this respect. However, the new list will be more user-friendly. For example, certain ingredients will be, the names of certain ingredients will be modified. There will be a human use part and a distinctive separate veterinary use part. I don't know about you, but the way it's arranged now with kind of the Part 1 and the Part 2 always confuses me, so this will alleviate some of the confusion. And changes to the new list will be easier, either adding or removing ingredients, and this will be done through a simplified administrative process rather than a legislative process. Currently, a regulatory amendment is required to make such changes. And Health Canada's criteria and decision-making process for making changes to the list are discussed in detail in a proposed guidance document entitled Determining Prescription Status of Human and Veterinary Drugs. The consultation period for this guidance document ended March 7th, but the draft guideline is still posted online. You could read it online. And this is potentially an important development for industry because it may facilitate broader access to certain ingredients hitherto unavailable to NHP formulators. Our next topic is the Low-Risk Veterinary Health Products Pilot Project, or LRVHP. Now, this is not really a regulatory update because it has been in place for about a year now, but I find that many in the industry still are simply not aware of it. Legally, you need a DIN to sell a veterinary health product. However, under the new pilot project, you can sell veterinary products without the risk of enforcement action. Now, does that sound familiar? It's like selling an NHP with only a submission number. If, first, you submit a formal notification application. Second, you attest to having adequate safety and efficacy data to support your claims. You don't have to submit them. You attest to having them. You attest to making the product in accordance with GMPs. The product is only for use by dogs, cats, and horses. So those are the exclusive types of animals. The product, fifth, is formulated only with ingredients on the list of admissible substances. This is a list of substances that they have prepared, and it's not etched in stone. Modifications can be made to the list. And finally, only general health claims are made. So it's as simple as that. If you are considering going to market with veterinary health products, you should look into this pilot project. It's far less rigorous, time-consuming, and costly than the DIN approach. And my final topic is the improved food inspection model. Now, this is an important issue because many of our listeners have food products, or if you didn't have them before, many of you do have them now as a result of the food-like NHP transitions. So this will be of concern to many of you. A draft model of this proposed model was posted. A draft of this model was posted for a consultation period which ended October 2012. This is part of the whole food modernization agenda that Health Canada is pursuing. Based on stakeholder feedback, the CFIA very recently developed a revised draft, or Draft B, which is now undergoing a second round of stakeholder consultation. Some of the highlights of the proposed model are as follows. Parties that import, export, or prepare food destined for interprovincial trade will be required to hold a license. So before, licensing applied only to specific commodities, example, meats, dairy, etc. Now it will apply to all foods, and it will be a single licensing system covering all foods. Parties that sell food intraprovincially, facilities that only store food, and retailers that do not import or export food will not require a license. An application for license must be submitted to the CFIA along with the appropriate fee, and exactly what that fee is remains to be seen. Parties must implement an effective preventative control plan as part of the condition for receiving and maintaining a license. This is essentially a quality control program similar to a GMP or HACCP type program. And licensed facilities will be subject to inspections by the CFIA. Now, inspections will not be a prerequisite for getting a license, but they will be auditing facilities who have a license. And the level and frequency of audits remains to be seen, but it will be based on a risk-based approach, example, the type of products, the history of compliance of the company in question, etc. It's not on my slide here, but the target date for finalizing the proposed model is spring-summer of this year, and it will be followed by a 3-year phased-in implementation period. And with that, I would like to now introduce our next speaker, Toby Ann Pinder, who is Dicentra's Legal Regulatory Affairs Associate. Toby Ann is both a licensed naturopathic doctor and a lawyer. She holds a doctorate in naturopathic medicine from the Canadian College of Naturopathic Medicine, a law degree from the University of Toronto, and a Bachelor of Science honors from Queen's University. At Dicentra, Toby Ann works exclusively on food regulatory matters, and as such, leads all projects related to TMAs, novel foods, and food safety standards. Toby Ann?
Thanks, William. Today I'm going to be explaining what a temporary marketing authorization is and how it can be utilized to achieve market access for your food product. While TMAs have existed as a regulatory tool in the Food and Drug Regulations for quite some time, it has only recently likely come to your attention, with some of you perhaps getting very familiar with the process, when it was used as a mechanism through which products involved in the food-like NHP interface were transitioned from the NHP to the food regulatory environment. After I talk a bit about TMAs generally, I will also give a brief update on the status of the food-like NHP transition. Normally, foods sold in Canada must meet the requirements set out in the Food and Drug Act and the Food and Drug Regulations pertaining to foods. To permit the sale of a food that does not meet the Food and Drug Regulations would usually require a regulatory amendment, which you can imagine is an extensive process. However, a temporary marketing authorization, or TMA, is a regulatory tool that permits a non-compliant food to be sold on the market while information is generated to support an amendment to the FDR. Since the purpose of the TMA is to gather specific data to make regulatory amendment, the manufacturer or distributor is required to gather this data in a manner agreed upon with Health Canada and to submit the data to Health Canada within a specified period of time. Currently, this has been set as annual reporting. To obtain a TMA, the applicant must provide certain mandatory information. The Food Directorate will review this information, and in the end, the applicant will have to sign a letter of agreement. This letter of agreement becomes part of the temporary marketing authorization letter and demonstrates the manufacturer or distributor has agreed to certain terms and conditions. This includes agreeing to any subsequent request from Health Canada to withdraw the product from the market or to reformulate. It's important to remember that a temporary marketing authorization letter is issued for a specific food formulation and specifies the restrictions and conditions of the TMA, as this forms the agreement with the government authorizing the sale of the product. The temporary marketing authorization letter, along with the letter of agreement, usually states things like the common name and description of the food to be sold, the name and address of the manufacturer or distributor of the food, the purpose for which the TMA is authorized, the quantity of the food that is authorized for sale, the period of time for which the food may be sold, and the designated area within the food which the food may be sold. The TMA guidance documents from Health Canada set out the information that is required in a TMA submission, but generally the information required of a TMA submission are things like the contact information of the manufacturer or distributor or the TMA holder, the purpose for which the TMA is requested, the description of a food, including a proposed label, and this also includes a formula breakdown for all ingredients and further information of specific ingredients like extract information, the format of the food, projected sales and distribution and proposed period of time required for such a sale, proposed nutrients or other labeling claims, suggested statements that may inform or mitigate risk to consumers, description of how the proposed food is not compliant with the FDR, adequate data to show the use of the food will not be detrimental to the health of the user, and finally, an attestation that the information in the submission is accurate and true. When preparing TMA submissions, an important first step is to first review this information to determine temporary marketing authorization eligibility of the product. Not all products will be TMA eligible. For instance, they may already be a compliant food. They may not be in a format considered to be typical of a food, or they may contain ingredients that are a novel food ingredient or unaccepted food additive that should first be approached through the appropriate food regulatory channel. As mentioned, the purpose of a TMA is for Health Canada to gather information to amend the FDR. Therefore, while these products are on the market, the applicant must agree to collect and submit to Health Canada certain information. Generally, two areas have been set out in the temporary marketing authorization letters for required research to be conducted during the TMA period. These are marketing research and incident reporting. Marketing research includes three core areas: annual sales, information on demographics of users, and information on specific marketing activities. Incident reporting will be things such as adverse event reporting and annual incident summary report. Further information regarding the collection of these is intended to be released by Health Canada in new guidance documents by mid-2013. Although current holders of temporary marketing authorization letters from the food-like NHP transition should expect correspondence from Health Canada regarding these reporting requirements in the upcoming months. Initially, Health Canada set proposed performance targets for the management of TMA submissions for foods that were at the food-like NHP transition, so those that were previously regulated as NHPs. These targets were dependent on the amount of information request notices issued and were based on a case-by-case responses by individual applicants. But for new TMA submissions, Health Canada is reevaluating these performance standards along with stakeholder feedback and expect to release new processing standards in the spring of 2013. So what happens at the end of a TMA period? Health Canada will analyze the data gathered through the research process and will work towards finalizing regulatory decisions or amendments to the food or food category in the FDR. It's important to note that the specific requirements in the final proposed regulations may be different than the specified requirements in the TMA. Nevertheless, the product must be in compliance with the final regulation when it comes into force. Now for the food-like NHP transition update. Health Canada recently gave an update on the food NHP transition in a webinar on March 19, 2013, where they reviewed the history of the transition through to the key steps that they expect from this transition. As a reminder, though, the food-like NHP transition was phased in where caffeinated energy drinks were transitioned first following a ministerial announcement in October 2011. Additional categories began to transition in April 2012. As of April 17, 2012, the NHPD no longer accepted NHP applications for products that were represented, packaged, or sold as foods. And the transition process was completed by December 2012 in advance of repealing UPLAR in February 2013. Some key stats that were brought up in this webinar regarding the transition. For caffeinated energy drinks, during the transition, 188 product license applications were identified as caffeinated energy drinks. 35% of these were subsequently canceled or withdrawn, and 1/3 of those were transitioned caffeinated energy drinks that had to change their product composition, 75% of those having to reduce their caffeine content. For the other food-like NHPs that are non-caffeinated energy drinks, 601 product license applications at the food NHP interface were identified as eligible for the transition. Approximately 50% of these were subsequently canceled or withdrawn. A small number of these were identified as meal replacements and have been subsequently treated separately by the Directorate, and 1/3 of the transition products were determined not to require temporary marketing authorization letters, for instance, if they were compliant foods. All the other TMA Ls have now been issued for the products at the food-like NHP interface. Excuse me. The expected next steps in the food NHP transition. In the spring and summer of 2013, the caffeinated energy drink guidance document from Health Canada will be updated to reflect the completion of the food NHP transition and to add further clarification on certain sections. In the summer-fall 2013, all the other non-caffeinated energy drink category-specific guidance documents for remaining categories of TMA foods should be released by Health Canada. Health Canada is also working with individual manufacturers and industry associations to develop research protocols for the specific information that is required to be gathered during the TMA period. Further communication is expected in the upcoming guidance documents relating to this. Annual reporting of adverse health incident guidance for industry, including a form to use for these, will be shared with TMA holders and applicants, hopefully within the upcoming weeks. Health Canada also plans to have information and education materials developed to increase consumer awareness and understanding for these types of foods and how to make informed decisions when including them in their diet. And then piloted in the spring of 2013, Health Canada also plans to provide updated performance standards revised on the stakeholder communication. I'd now like to introduce our guest speaker, Alice Sang, who is a partner with Blake, Cassels & Graydon and is both a pharmacist and a lawyer. Alice's practice focuses primarily on regulatory and marketing matters in the pharmaceutical, medical device, and food industries. In the pharmaceutical sector, Alice has extensive experience advising clients on rebate, reimbursement, and interchangeability issues, advertising and marketing campaigns and programs for healthcare professionals, patients, and consumers, healthcare compliance, access to information, privacy, anti-spam, product and site licensing, and other matters relating to the marketing and sale of drugs.
Hi, I'm Alice Sang, and I'm going to give a brief overview of Canada's new anti-spam legislation, also known as CASL, C-A-S-L. CASL is expected to come into force either later this year or next year, after the Industry Canada regulations have been finalized. Industry is very concerned about CASL for a number of reasons. One, CASL is considered to be the toughest anti-spam legislation in the world. If you are already familiar with the U.S. Can-Spam Act, you should know that the Canadian law is stricter, and compliance with the U.S. law may not be sufficient to comply with the Canadian law. Secondly, breaching the legislation can result in a penalty of up to $10 million. And third, CASL contains a private right of action. This means that if you breach the legislation, you could be at risk of class actions. CASL prohibits a number of activities that are unrelated to spam. So I've listed the main prohibitions here, but I will only be speaking about the first one, the anti-spam prohibition. This is the key anti-spam provision in the legislation. Essentially what it says is, it is prohibited to send a commercial electronic message, or a CEM, unless two things. Unless A, the person to whom you are sending the message has consented to receiving it, whether the consent is express consent or implied consent, and B, the message itself complies with certain form and content requirements. In the following slides, I will set out what a CEM is, what constitutes express or implied consent, what exemptions exist, as well as the form and content requirements themselves. So first, in terms of what is a commercial electronic message, CASL essentially applies to communications like emails or text messages and likely some social media messages. It applies to these types of communications if at least one of the purposes of the message, of the communication, is to encourage participation in a commercial activity. You should know, and this is very important, you should know that an electronic message that requests consent to send a CEM is itself considered to be a CEM, meaning that you can't even send a request for consent to someone unless you already have express or implied consent. So I say that's a big distinction between the U.S. CAN-SPAM Act and CASL. I've already mentioned that in order to send a CEM, you need to have either express or implied consent. So this slide talks about what you need in order to have express consent. It sounds easy and reasonably enough that you can only send a CEM if you have express or implied consent, but it's really not that straightforward or simple. The regulator will only consider someone to have provided express consent if certain conditions were met, including if the person actually opted in to receive a CEM. So opt-out consent is not good enough. You need opt-in consent. For example, the person must have taken an active step, such as checking a box to indicate that they consent to receive emails. If the box is pre-checked, that doesn't count as valid express consent. In addition, a request for express consent has to set out certain information, which I've listed on this slide. For instance, you need a statement that the person can withdraw their consent. If you don't have express consent, you can also send a CEM to someone if there is implied consent. However, consent can only be implied in the limited circumstances that are listed on the slide. For instance, if there's an existing business relationship or an existing non-business relationship with someone, something like that. However, you should know that what constitutes an existing business relationship or an existing non-business relationship, for instance, is set out in the regulations. So unless the proposed Industry Canada regulations are actually revised, then an existing business relationship is only considered to exist under certain limited circumstances, such as if someone has purchased goods from you within the last 2 years, or if they've made an inquiry or application with you in the last 6 months. So it's pretty restrictive. There are, of course, exceptions to the requirement to have consent. So you could send a CEM to someone who hasn't already consented to receive that CEM if the CEM solely does one of the following. For instance, if the CEM solely provides warranty or safety information. To the extent that the CEM provides other information, such as if the message includes a request to send marketing information, that no longer fits this exemption because it's not just solely providing warranty and safety information anymore. There are also exemptions not just from the consent requirement under CASL, but also there are exemptions from both the CASL and the form and content requirements. So if you're sending a CEM to someone with whom you have a personal or family relationship, then you don't need consent and you don't need to meet the form and content requirements. However, you should also know that what constitutes a personal or family relationship is defined under the regulations, which may or may not be identical to what you would consider to be a personal or family relationship. I've set out on this slide the form and content requirements that each commercial electronic message, that each CEM must have. As with the rest of the slides, I'm just providing a very, very brief overview in my oral comments. The written slides have additional information. I already mentioned earlier the stringent, the very severe consequences that can occur when the legislation is not complied with. for instance, the potential for class action. I've obviously only provided a very, very brief overview of CASEL. For more information, you can go to the Blake's website, that's blakes.com. We have a microsite on CASEL which contains various bulletins and other resources. Although CASEL will not actually come into force until later this year or possibly next year, you should know that is definitely to your advantage to understand CASEL and take steps now to start complying, because there are also transitional provisions under CASEL which you can only take advantage of if you know in advance what's required under CASEL and take steps to comply. I'd like to thank Dicentra for this opportunity to present to your viewers, and I will now turn this over to William. Thank you.
Thank you, Alice, and thank you to all our participants for joining us today. We invite you to visit our website for a video of this presentation and for a list of all links mentioned. Join us for our next regulatory update on Tuesday, June 18th, 2013. You can learn more about Dicentra by visiting dicentra.com or by contacting us at 1-866-647-3279. Thank you again, and have a wonderful day.